Hello, today we will consider general exceptions under Indian Penal Code. Under Indian Penal Code, these general exceptions have been placed and grouped under Chapter 4 of the Indian Penal Code. The general exceptions have been grouped at one place in Chapter 4 of the Indian Penal Code to avoid the necessity of repeating it in the other parts of the Indian Penal Code. While understanding every definition of an offense, every penal provision, and every illustration of a definition under Indian Penal Code, these general exceptions have to be kept in mind. To put it in other words, every offense, every penal provision, and every illustration of the definition will be construed, will be interpreted subject to the provisions contained in Chapter 4, that is the chapter of general exceptions. The general principle of law is that a man is presumed to know the nature and consequences of his act, and therefore that man is held responsible for it. But then there are certain exceptions to this general rule, and if these general exceptions are present in a particular case, that man, that person may be excused of the crime. Chapter 4 of the Indian Penal Code consists of total 31 sections, and these 31 sections can be understood by grouping them into 8 heads. The first group is of mistake of fact and mistake of law, that is relating to sections 76 and section 79. The second group is of privileged acts, that is judicial acts, sections 77 and 78. The third group is of accidental acts, that is section 80. The next group is of necessity, that is section 81. Fifth group is of incapability to commit a crime. That group consists of sections 82 to 86. Sixth group is about acts done with consent, sections 87 to section 9, and also of the acts without consent, that is section 92. The seventh group consists of triviality, section 95. Triviality means smallness, less important things. And the last group, that means the eighth group, consists of private defense, that's from section 96 to 106. If you bear this grouping into mind at the time of studying this chapter, it will be easier for you to understand the entire chapter relating to general exceptions. Apart from the detailed groupings that we saw just now, chapter 4 can also be divided into two broad groups. The first is excusable exceptions, and the second group is justifiable exceptions. Now I will tell you the difference between the two in a second. In the first category, that means in the category of excusable exceptions, mens rea for the offense would be lacking. Mens rea means guilty mind, guilty intention. That would be lacking in the first kinds of cases. The absence of guilty mind or absence of mens rea in the first kinds of cases can be because of certain factors, such as a bona fide mistake as to the existence of a fact, or by the reason of the act being done accidentally, or because of infancy, or because of insanity, or intoxication. And therefore the doer is not responsible for what he has done. That was about first category. Now in the second category of cases, that is the category of justifiable exception, the circumstances under which the offense was committed, those circumstances furnish legal justification for its commission. For example, a judge acting under the direction of law, or some another person acting under the directions or orders of the court, or some person acting to prevent a greater harm to person or property in the case of necessity, or it could be an act done with the consent of the person harmed, or it could be an act done in the right of private defense, or it could be an act of a very trifle nature, so trifle, so trivial, that the law would not take note of it. Now, before we go to understand the sections in detail, it is important to understand something about burden of proof. On whom would the burden lie to prove the general exceptions involved in a crime is the most crucial question. Generally, the burden of proving the charge against the accused lies on the prosecution and not upon the person who denies it. That means not upon the accused. This has its roots in Roman law. The principle states that he who seeks the aid of the court should be the first to prove that he has a case. Accordingly, the burden of proving that the accused committed the criminal act, and that too with a guilty mind, is upon the prosecution throughout the trial. It never shifts to the defense. For example, in a criminal case where the accused is charged for murder under section 302 of Indian Penal Code, it is the duty of the prosecution to prove such intention or knowledge as is mentioned under section 300 of Indian Penal Code. So long as the prosecution fails to prove such intention or knowledge, the accused is entitled to acquittal on that charge. There is no burden of proof on the accused to prove any special plea or to prove any exception. But where the prosecution successfully establishes before the court all such evidences which go to prove the guilt of the accused beyond reasonable doubt, and if the accused wants to claim benefit of any of the exceptions as stated in this chapter, then The burden of establishing an exception which will entitle the accused to be exempted of the charge is on the accused. It is on the person who wants to bring his case within any of such clauses. It is the accused who is required to show that his case falls within one of the exceptions provided in Chapter 4 of the Penal Code, dealing with general exceptions, or within any special exception or proviso contained in any other part of the code. For example, exceptions 1 to 5 of section 300 of IPC, or any law defining the offense. The burden of proving an exception thus lies upon the accused. Okay, with this much introduction, let us now move to the sections.